Just give me one moment, Mr. Allen, if you will. Yeah.
My lords, my lady, I appear on behalf of the defendants. My learned friend, Mr. Williams, King's Counsel, and Mr. Eastwood appear on behalf of the claimants. And my learned friend, Mr. Weir, King's Counsel, and Mr. Way appear on behalf of the interveners, the Association of Personal Injury Lawyers and the Motor Accident Solicitors Society. I introduce the parties as by reference to claimant and defendant because this is a pair of appeals in which there is appeal, and cross-appeal. So to avoid any confusion, subject to your views, we propose to refer to the parties as they were originally identified.
Claimants and defendants.
Yes.
Very good.
Can I start with some housekeeping, please? In terms of your bundles and paperwork, you should have either electronically or in paper form the following. In the Rabot appeal, we have the core bundle and the supplementary bundle. And with the cross-appeal. In the Briggs appeals, there's the joint core bundle and the joint supplementary bundle. And finally, there are 2 volumes of authorities bundles. Hopefully for you, and we've checked here, that the pagination in the paper bundles corresponds to the electronic bundles, so we don't have to have multiple page references.
Thank you very much.
In terms of timing, again, subject to the court's views, we've discussed the allocation of time, and that with a full court day, assuming that remains the appropriate length for the hearing, we anticipate to be approximately 2 hours on behalf of the defendants. Similar time for my learned friend Mr. Williams. The interveners have been allocated by my lady's order 20 minutes for oral submissions. Query whether I think my learned friend Mr. Weir might want or need a little extra on that, and then a short opportunity for reply on behalf of the defendants at the end of the day.
On we go.
Grateful. So, Part 1 of the Civil Liability Act 2018 and the Whiplash Injury Regulations 2021 introduced a system of fixed tariff awards for damages for pain, suffering and loss of amenity for whiplash injuries or whiplash injuries plus minor psychological injuries sustained by car drivers and passengers as a result of road traffic accidents. The tariff applies to claims arising out of accidents which took place after the 31st of May 21, where the symptoms attributable to the whiplash injuries last up to 2 years. In doing so, Parliament displaced the common law assessment of non-pecuniary damages for pain, suffering and loss of amenity in respect of those category of injuries sustained in those circumstances. The issue before the court on these appeals, captured by my lady when issuing case management directions, is how is the court to assess damages for pain, suffering and loss of amenity where a claimant sustains a qualifying whiplash injury which falls within the scope of the Civil Liability Act and attracts a tariff award, but also suffers additional injury which falls outside of the statute and does not attract a tariff award. In headline, in terms of the competing approaches advocated by the parties and the intervener, we say that the defendant's approach is consistent with the legislation and the common law, whereas the approach of the claimants and the intervener are inconsistent with the legislation and the common law. It's for that reason we say the defendant's approach, as articulated in our skeleton arguments, is to be preferred. The appeals arise out of 2 cases heard by the same District Judge Hennessy, sitting on different dates at the Birkenhead County Court. The facts of each case are set out in the statement of facts which can be found in your bundles in Rabot in core bundle, page 28, and in Briggs, the joint core bundle, page 29. To give a context to the judge's decision and the issues before the court in the individual appeals, we propose just to outline in summary the facts of each.
I don't think you need to. We've really read the papers.
I'm grateful, Madam.
Mr. Allen. I mean, you know, I think that it's a question of principle, isn't it, really?
It is.
I mean, there's one or two little wrinkles, like can you go below the award that you assess, if you have to, for the non-tariff injuries?
Yes. In terms of the facts then, you've read it. One point we would highlight is, and it feeds into some of the points the intervener seeks to make, both of these appeals were cases in which the judge made a clear finding that there was overlap between the tariff injuries and the non-tariff injuries. That led her to make the adjustment, or conclude that an adjustment by way of reduction.
If there's no overlap, there's no problem, is there? If there's nothing concurrently caused, you've got your tariff award for the whiplash, there's no overlap with the non-whiplash injury, you just award what you'd award for the non-whiplash.
If there's a bright line distinction between the two, my lord, yes. If it is clear that there's no overlap there, that these are completely, wholly separate,
Yep.
self-standing, that the non-tariff is...
With no concurrently caused consequences.
Agreed.
Yep.
And it is on the non-tariff then, it just feeds into what award for that represents what's just, fair and reasonable.
On that basis, do you say that it's ever possible in such a case, leave aside where there's an overlap,
Where there is an overlap.
where there is an overlap, for there to be an overall award which is less than would be awarded for the non-whiplash injury on its own?
Sorry, my lord, are we putting to one side the overlap, or are we looking at an overlap?
No, I'm now talking about, because this case doesn't arise unless you've got an overlap. So in a case where you've got an overlap, is it your case that the final award taking, which is meant to be in respect both of the whiplash and the non-whiplash, can be less than would be awarded if there had only been that non-whiplash injury?
Yes. To recognise, as would always be recognised at the common law, that where there is an overlap, to acknowledge that overlap.
Yeah, but that's where you've got a common law on both sides.
Well, we say it applies where you have the common law applying to the non-tariff element here.
All right.
But
I just wanted to be clear that
No,
that is your case.
That is our case, and that's Rabot and Briggs, isn't it? That we have a tariff and a non-tariff. We clearly have overlap, as the judge found, and our position is, in those circumstances, adjustment to the non-tariff to recognise that overlap to produce an award that's just, fair and reasonable.
So in those circumstances, the claimant would be sensible simply to sue for the non-whiplash. Full stop.
Well, no, because the claimant would have to disclose and provide information as to the extent of...
But if he doesn't claim for the non-whiplash, for the whiplash, you can't make him claim for the whiplash.
No, but the Act bites to a claim where whiplash is sustained, not where...
Okay, well, you'll explain that.
Yes. But on my Lord's point, that's our position.
Okay, thank you.
And so the parties and the intervener are agreed that in respect of mixed injury claims, the Act and the regulations displace the common law solely to the extent of the assessment of the tariff element of the award. That element is fixed by the regulations, albeit subject to the scope for an uplift of up to 20% where the test of exceptionality is satisfied. That doesn't arise here in either of these appeals. The parties also agree that the Act and the regulations do not displace the common law or the judge's task of assessing damages for any non-tariff injuries. So can we start by having a look at the authorities in relation to the assessment of personal injury damages, pain, suffering, loss of amenity damages at common law?
Wouldn't it be useful to hear what your case, why you say your case is what it is? Because what I find quite difficult is the meaning of the statute. Isn't that the primary thing to look at? I mean, Section 3.8 is, you know, what is said against you is that Section 3.8 gives you the clear green light. tells you what you should do, and you should assess both. And there you are, easy, as Mr. Ware says. What do you say Section 3.8 means? Well, it may not be just 3.8.
Well, no, 3.8, authorities bundle, page 9.
I quite accept that we need to look at the law as it was when Parliament legislated, but we need to look at the legislation to know what it was doing first, don't we?
Well, if we look at the terms of Section 3.8,
Well,
Yeah.
Mr. Allen, aren't the two critical parts, 3.2 and 3.8? You may want to go to 3.2 first because it leads into 3.8.
yes. 3.2, authorities bundle, volume 1, page 8.
We've got it engraved on our hearts already.
Well, the amount of damages of pain, suffering, and loss of immunity payable in respect of the whiplash injury or injuries taken together is to be an amount specified in the regulations made by the Lord Chancellor. So pausing there, it prescribes that for the tariff element of a claimant's injuries, the figure must be the figure that is allocated to it according to the tariff under the regulations.
So
And
the
you don't get
critical-
into 3.2 unless a claim is made for a whiplash injury.
Pardon, my lord.
3.2 is irrelevant unless a claim is made for a whiplash injury.
Yes.
Thank you.
And the critical words of 3.2 are is to be an amount specified in regulations.
Yes.
So that is the hide bound, it's got to be within the tariff.
Yes.
Whether it is column 1 or column 2, it's got to be within the tariff.
Absolutely. Albeit subject to the exceptionality uplift. But my lady's right. It has to be. And so, coming to Section 3.8 then.
Can I just ask you why you agreed with my lord?
No.
Sorry.
You agreed quickly with my lord when he said you don't get in to 3.2. You don't get into, I think you, sorry, I didn't write it down. You don't get into
3.2
3.2 unless a claim is made for whiplash injuries. And of course that's,
Well,
he's laying that as a foundation for the proposition that you can make a claim just for your knee injury and not make a claim for a whiplash injury even if you've suffered it, which for my part anyway could have problems about the medical report parts of this legislation, which doctors probably wouldn't ignore injuries in that kind of way. But it doesn't say that. It simply says the amount of damages for pain, suffering, loss of amenity payable in respect of whiplash injuries is to be a certain amount. It doesn't say that it doesn't, that it's not really about whether or not a claim is made,
no,
is it?
sorry, my lord. It was, my understanding, my lord's question was whether there was the fact of a whiplash injury was before the court. If there is a whiplash injury that is to be compensated, then it will attract that figure
Yes.
under 3.2.
Well, that's all it's saying.
Yes.
It's not really saying anything about whether or why or when a claim is made, or who's making it or why,
No.
or what the effect of not making it is.
If there is a whiplash injury within the scope of the Act for which compensation is to be assessed, it is assessed
Yeah, okay.
applying the regulations.
Yeah, keep going. So we can now go to 3.8.
3.8 at page 9.
Yeah.
So again, I suspect this is a section that has been read and reread by the court.
It's also engraved, yes.
Our position is that the terms of 3.8, the language of 3.8, does not compel or oblige the court to take any specific approach to the valuation of non-tariff injuries specifically.
So what's it there for?
To preserve the common law approach and the options available at common law to a judge assessing a mixed injury case, and in particular the non-tariff element of that. We say that because of the language, nothing in this section prevents. So it makes clear that it is open to a court in a case in which the claimant suffers injury or injuries in addition to injury or injuries to which regulations under this section apply. So in a mixed injury case, where there's tariff and non-tariff injury, that the court may, nothing in section 3 prevents the court from awarding an amount of damages for pain, suffering and loss of amenity that reflects the combined effect of the person's injuries. What 3H also makes clear is in the mixed injury case, and this is common ground between parties and intervener, is that that assessment in the mixed injury case remains subject to the limits imposed by the regulations, i.e. my lady's point, that the tariff element is fixed by the regulations and cannot be departed from.
So what does the combined effect of the person's injuries mean?
The total for pain, suffering and loss of amenity attributable to the totality of the injuries. Whether to such extent pain and suffering and loss of amenity is discretely attributable to one injury, the extent to which it's discretely attributable to another, and recognises the scope for damages to be awarded where there's overlap.
Sorry, I don't understand that.
Well, in terms of the combined
You're
effects,
going to have to go more slowly. Mr. Weir says that the combined effect of the person's injuries preserves the common law right to assessment of all the damages, irrespective of what may also have been caused by the whiplash, for the additional injury, right? Now, do you agree with that or don't you agree with that? And if you don't agree with that, why does your case come out of the words combined effect of the person's injuries?
because the reference to combined effect refers to the totality of the effects of the injuries, plural, tariff and non-tariff.
Subject to the tariff, it says.
Yes. So that any pain, suffering and loss of amenity attributable to the whiplash injuries is compensated by the whiplash award. The court can make an award in respect of the non-tariff injuries for additional pain, suffering and loss of amenity.
But unfortunately, that's fine. That would be fine, except the whole thrust of the legislation is to prevent the need for assessing what the pain, suffering, loss and amenity of the whiplash injury is, because it's fixed by the tariff, and it's the only assessment is made is how long it's going to last.
Yes, but in mixed injury cases, in order to identify the extent to which pain, suffering and loss of amenity is attributable to the non-tariff injuries, it's unavoidable, and we say essential, that findings are made as to the extent to which pain, suffering and loss of amenity is attributable to the whiplash.
But how do you do that? I mean, let's just look at the hearing. It is described as a streamlined hearing. There are reports before the court which are very, very contained medical reports, and they're really directed to duration, because that is what the regulations contemplate.
But we can see in these appeals that the district judge, with the material that she had, was able to make clear findings on those very issues. So
Well,
by
she
way
has
of...
to. She has to. That's her job.
Yes.
But the materials on which she's required to work are skinny.
The medical reports appear to have been written for the purpose of such proceedings.
Agreed.
Yes. They are in a particular form and do not contain the amount of detail that one might have seen in other proceedings where you are doing what might be described as the full common law assessment. So how then is the judge in an informed position to make a full assessment of any sequelae?
Well, in a mixed injury case, by definition, the judge is undertaking a common law assessment.
Of what?
Of the non-tariff injuries.
I got that. I'm
So-
talking about the whiplash.
Well, but therefore those reports that within the confines of the fixed fee and the system are able, the experts are able and needed to include their assessment of severity, duration, impact of the non-tariff. It's an equally simple exercise for them to address, as they did, as the experts here did. They described the loss of amenity. They described the duration of symptoms. The claimant in at least one appeal was invited to give a pain score by reference to immediately, I think when assessed at 2.5 months.
Let's give a different example, which is more clear. Mr. Ware's example of the badminton game. Now, let us assume that the doctor says that this patient has presented and his injuries prevent him playing badminton for 3 months, right? Which is what he does for a living, or what is very important to him, right? And does not say whether that's caused by the knee or the back. And how is the court to determine whether it would have been caused, whether the same injury would have been, the same consequence would have arisen if there had just been the whiplash, in order to decide what the appropriate addition is or appropriate reduction on standing back on your case?
Well, it has always been, well, it has always been the case that a judge, prior to the regulations, undertaking an assessment in a case such as this, would have similar medical report with similar information and similar evidence. That judge would have to make findings sufficient to make an award in respect of what is now the tariff, but the whiplash plus any additional. Insofar as there is overlap, then, as here, it wouldn't simply be, in my respectful submission, just the bare headline of both injuries were symptomatic for 3 months, he couldn't play badminton. There'd be evidence as to, or information as to, the severity. Sorry, my lord, you want to jump in?
Yeah, no, I'm doing quite well biting on my tongue. This case would be dead easy if one could tell what was in the tariff award, how much was in for what. So if one could tell that within the tariff award there was a figure of X for the concurrently caused injuries, or a concurrently caused loss of amenity, there wouldn't be any problem. It would be a normal common law approach. You'd just say, well, look, I've got the whiplash injury and that would have caused him to be off badminton for 3 months. I've also got the knee injury, that would have caused him to be off for 3 months. I'm not going to give him the full compensation that I would give for either if they stood on their own, because I've got to take into account the fact that there's a concurrent caused area in the middle. And you would know, or the judge would form a view, might not be expressed, but would form a view that in his notional award or her notional award for the whiplash, there was £500 for the loss of the badminton. And similarly, in relation to the notional award for the knee, there'd be £500. And you'd do an adjustment. And that's classic Sadler, easy. The only problem in this case, to my way of thinking, is that we don't know in a tariff award how much is there for the loss of the badminton.
And there are two problems. Okay, sorry.
Another problem, my lords will definitely have always.
The first problem is that you don't know how much is in the tariff for the badminton. And the second problem is that the amount in the tariff for the badminton is suppressed considerably from, say, 10 to 1. And the question then is, do you compensate for the badminton caused by the knee with the extra 9?
Well, to your second point, our submission is no.
I know that's your submission, but that's not their submission.
No, but that would offend the prohibition on at 3.8 that the assessment is subject to the restrictions imposed by the legislation, by the regulations, because by filling the gap of the 9 on the grounds that, well, the whiplash element has been suppressed, in my lord's example, is effectively increasing the award that's being given.
But the regulations say nothing about the common law assessment of damages for the knee.
No, but on the first of the 2 points, and start with my lord's point, first of all, the authorities discourage any sort of approach where there's a mental allocation of different figures to different strands, that there's this for pain, there's this for suffering, and there's this for loss of amenity. Explain that that's not what one does. It is
That's not what Lim says.
It's a figure. Well, in our submission, and as we see in the authorities here, that there is acknowledgement of, on the totality, on the effects of pain, suffering, and loss of amenity, what is the fair and reasonable award for that as a whole, as a parcel. That to extract and to say, and we don't see in Sadler, we don't see in the minor injuries case in Highland Rankin, any analysis where there is a balancing of, well, I've captured loss of amenity with that for the whiplash, and then that feeds into what's allowed for the non-whiplash or for the non-tariff. The regulations and the Act make it clear that whatever the pain, suffering and loss of amenity attributable to the whiplash, that is compensated in full by the application of the tariff. It is less than claimants would have received before the date in which this came into force. It's less than the hypotheticals of somebody who suffered similar injury in non-car accident circumstances. But that is the goal and the objective which Parliament has achieved and implemented by this legislation. So insofar, there's no requirement in our submission to have a sense of or appreciation of what the element is for loss of amenity, because whatever the loss of amenity is attributable to the tariff injuries, that is compensated in full within the tariff award.
For a whiplash.
For a whiplash or...
But the statute says nothing about the assessment of common law damages for non-whiplash injuries.
Agreed. But then that's why we say it is a fact-finding exercise, as I think we've covered already, that in a wholly common law assessment, the findings we suggest are required would have to be made. For non-tariff, in these claims now, these findings have to be made, and it is in our submission, a simple and straightforward exercise for a judge to form a view as to the extent to which, and it's probably most obviously loss of amenity, isn't it? My Lord's examples, going to the badminton, pain and suffering will be described by the claimant, how painful it was for what period. Loss of amenity is where there's the overlap. But a judge will be able to form a view, and we can come to the judgments here and to see what the district judge actually said, as to the division or demarcation between loss of amenity, the extent to which loss of amenity is attributable to tariff and non-tariff. Knowing what the figure is within the tariff award doesn't matter for that because it's compensated in full. What the judge has to form a view on is what represents fair and reasonable compensation for that element of pain, suffering, and loss of amenity which they attribute to the non-tariff injury.
Assessed on common law principles.
Assessed on common law principles.
That's your problem, though. Because the consequence of your argument is that you do not assess the damages for the non-whiplash on common law principles.
Well, we say you do, because
you say it's predetermined by the fact that it's already in the whiplash injury, and therefore you're not going to award anything for the overlap in assessing the non-whiplash injury.
The defendant's position isn't and has never been that there's not going to be any award in respect of concurrent symptoms. There can be an award where there is overlap, but the figure for the non-tariff injuries is adjusted to take into account that. The extent to which it is attributable to tariff injuries is already compensated by the tariff award.
You're confusing if I may respectfully say so, you're confusing your causation language. We're really only concerned with concurrently caused loss of immunity, let's say. And what you're doing is you're saying the concurrently caused loss of immunity only sounds in the whiplash assessment.
No, that's not what we're saying.
Well, in that case, I don't understand what you're saying.
Well, no, because in the concurrent cause where there is overlap between the two injuries, the position is that there is a common law assessment of the non-tariff, Everybody agrees upon that. That's the position of all parties in the intervener. That is assessed at common law. At common law, if we're in the concurrent cause, the mixed injury cases, and if we look at one of the cases in Highland Rankin as an example, it's exactly the approach that's taken, that we suggest is taken now, and is consistent. Is the approach we suggest isn't novel or evolves as a product of the legislation. Can I invite the court to Authorities Volume 1, 249, the case, it's one of the individual cases, it's Connolly and Tasker.
Now, you promised me that the pages would be the same, but page 249 in the electronic bundle is the middle of a case called Connolly and Tasker.
Exactly right. Sorry, my lord. Highland Rankin is the umbrella term or the overall name for the group appeals. Within that, there were a basket.
Showing my ignorance. Thank you.
There's a basket of appeals or test cases in which the approach was tested and considered. So the bottom of 249 is Connolly and Tasker. And if we turn over to 250, starting at 179, the claimant, Mr. Connolly, sustained a whiplash injury and 2 fractured ribs in a road traffic accident on the 19th of February 98. So mixed injury, whiplash, 2 fractures, chest pain. We can see from the narrative that the fractures and the chest pain lasted for approximately 8 months, the chest pain for 8 months. The whiplash persisted at the date of trial, which was approximately 2 years post-injury. If it were now, probably a case that would be caught by the regulations, and it includes minor psychological injury with the claimant suffering loss of confidence, flashbacks, sleep disturbance, and so on. But if we turn, in terms of the Court of Appeal's approach to its assessment of the appropriate award there, para 191 on page 251, Lord Wolfe identified that looking at the whiplash injury alone, given the duration of symptoms, and it was slightly more complicated than might otherwise have been the case, the appropriate award for the whiplash would be in the bracket up to £3,500. So the whiplash injury represented the starting point, and then said the addition of the loss of confidence, sleep disturbance and flashbacks, together with a fracture of 2 ribs causing several months chest pain, suggests an award in excess of that sum. So up to 3,500 is the starting point for the whiplash. And then if we, Lord Wolfe looked at cases that have been referred to, and if we turn over the page to 195 at 252, the award made by the judge at first instance was 3,000. We are satisfied that the award of £3,000 for general damages in this case was inadequate on a conventional basis. A proper sum to compensate the claimant in respect of his whiplash injury, still unresolved at trial nearly 2 years after the accident, together with the rib fractures and loss of confidence, disturbance and flashbacks, is 4,000 when assessed on the conventional basis, then appropriate. So in our submission, it's exactly as we say here, to take a figure that starts for the whiplash injuries, which is now, rather than penciling in the figure that the court considers is appropriate as its starting point, the regulations dictate what the starting point is, and as my lady emphasised, it's fixed and immovable. And then to consider, well, to what extent do the additional injuries resulting in pain, suffering and loss of immunity sound in an increase or additional damages to acknowledge the impact of those? It's precisely what we say is done here. The only shift is, rather than a judge having to make an evaluative judgment of the whiplash element, that's anchored in the regulations and represents the starting point from which the judge has to consider, as Lord Wolfe did here, as district judges have done up and down the country, up to and beyond the introduction of this legislation, to produce such additional allowance as they consider is fair and reasonable, taking into account that the effects of the whiplash injury are compensated by the term.
So you say, if you imagine a person with 4 injuries, a bad toe, a bad finger, a bad chest, a whiplash and a bad rib, you don't take each one and assess pain, suffering, loss and amenity for the toe, pain, suffering, loss and amenity for the others, and add them all together, you take the one that has the greatest causative element, say whiplash in this case, and then you say, well, but it was a bit worse because his toe was hurting at the same time.
But, exactly.
But this is just shorthand, and it's predicated on the basis that common law damages are being awarded for both. So you take, in this case, you take the whiplash and the stuff that's put in at £3,000, and you say, well, the additional contribution over and above is the fracture. But you're doing that on the basis that you've assessed both by common law principles. If for some extraordinary reason you just suddenly say, well, you can't recover anything for the whiplash, let us say, because Parliament has said you can't have anything for the whiplash, you've still got the 2 fractured ribs and whatever has happened, and you've got to look at what you should recover for them.
But we're not suggesting you don't look at what you recover for them, but you recover it in the way that's entirely consistent with the common law, because on the note from Mr. Weir's 3 presumptions, knowledge that the Parliament knows what the common law is, that any significant departure has to be express or implied, obviously created expressly or by implication, and third, what is necessary. On those presumptions to interpreting 3.8, all that Parliament has done is to fix the element for the tariff award. To then look at the compensation...
I agree. All it's done is fix what you get for the tariff.
Yes, but in producing at 3.8 preserves the court's ability. It doesn't dictate what approach must be taken. It says that the court may, or nothing prevents the court from making the award an award that represents the combined effects. But it's preserving the common law options that judges would always consider in a multiple injury case. This is a multiple injury case. The whiplash element is fixed, but the judges then on the common law assessment of the non-tariff has to follow from the fact that the effects of the whiplash injury are compensated in full by the tariff award. Otherwise, that approach leads to double counting. It leads to overcompensation.
No, not necessarily. No. Because, I'm sorry, it's just taking up my Lord's point. Your approach is based on the fact that there are 2 common law assessments. That's the whole approach that we've all used, the Sadler approach, if you want to call it that. You stand back at the end, you look at it and say, all right, totality, where do we stand? This is a very different case. This is a tariff award, which is clearly significantly lower than a common law assessment would have been. And then you have the common law assessment for the non-tariff injuries. How in those circumstances is it fair and appropriate compensation when you have one significantly lower award?
Well, Parliament has decided what the appropriate award is for the tariff. So anything, the level of the awards doesn't feed in and shouldn't feed into the legal approach to how one assesses the non-tariff. That's the view that Parliament's taken, balancing, and we see, I think, Limpo and others, that where there is to be inroads into the common law and the assessment, it is a matter for Parliament. Parliament has intervened in this area, and balancing all of those factors has identified that represents, on the totality, the appropriate sum.
Well,
but it is less...
Is the answer not to my lady's question your answer, not the answer? Your answer to my lady's question is Parliament has dictated that all the consequences, pain, suffering, loss and amenity of the whiplash injury is to be compensated by £500, say.
Yes.
And it is full and fair compensation for the knee, which would have caused exactly the same pain, suffering and loss of amenity, subject to a pain in the knee for a week or whatever additionally, for which you must assess on common law principles. You do not need to double count the assessment of pain, suffering, loss and amenity, which was there anyway, caused by the whiplash, because Parliament has said how that is to be compensated.
I had hoped that was my answer, but my Lord's captured it.
Well, I don't think I think it's the double counting point. I mean, it's the 9-1.
It is, but
the answer is that you do not any longer, if you have been stopped from paying badminton by both whiplash and the knee, you do not get the 9, you say, in the common law compensation for the knee.
Agreed.
And my Lord's question and my Lady's question would indicate you do.
Well, but it would be wrong because if, as we have here, if we actually, to give this exchange some context, my bundle in Rabot. Sorry, Lord.
You've given me just enough time to work out why I think your answer about your reliance on Connolly is wrong, but we'll come back to that in a moment.
If I speed up, my Lord won't have the same chance. But to give this, to bring it to these appeals, because rather than hypotheticals, in Rabot, if we take core bundle for Rabot, behind divider 9, page number, paragraph 35, this appears at page 76. The learned district judge identified correctly that her valuation of the knee injuries is assessed on the basis of the pain, suffering and loss of immunity caused by the knee injuries. And then if we turn over, we get to paragraph 40.
Which paragraph?
Sorry, paragraph 35, page 76 in the Rabot core bundle.
Yeah.
So having identified what it was that the non-tariff was targeted towards, at paragraph 40, page 77, I take into account that the injury was to both knees. I also looked at the JC guidelines to which I've been referred. I cannot discern any particular difficulty occasioned by the knee injury, but it was clearly painful to a degree over a period of time. And then at 41, having introduced, same page, having introduced the figures, stepping back, I think the overall award is 3,100 to recognise the clear overlap on the basis of the medical evidence I have before me. And then the last sentence, there is nothing highlighted in terms of particular loss of amenity that can be attributed to the knee injuries alone. So here, the findings, the sort of findings that we say a district judge should make, can make, and with proper assistance from medical experts will easily be able to make, the judge reached the conclusion that there was no clear or obvious loss of immunity that could be attributed to the knee injuries. Alone.
She says there's overlap, but there's nothing attributable to the knee alone.
Yes.
Yeah.
But in terms of, if we're balancing it here, my Lord, if you have the duration, the whiplash injuries here were of far greater duration. I think over double the duration of the soft tissue knee injuries. On the claimant's own self-reported pain scale, they were far more significant in terms of their impact upon him on a daily basis. Looking at the profile of loss of immunity that he described, a district judge could, this district judge did, and we say a district judge should form the view that the bulk of the pain, suffering and loss of immunity, whether we take the badminton example, is attributable and is compensated by the whiplash injury, by the tariff award, to such extent as the non-tariff contributed to the overall loss of immunity is something upon which the judge did form a view.
So why are you appealing?
Because the level of the award, the award itself is ultimately too high. We say that there's two aspects to it, my Lord. In terms of, on the principle, the judge
You can't appeal the amount, can you, by itself?
Well, the amount in itself, because of the flaws in the judge's approach, was too high. And my Lord will appreciate, as with the order for expedition, these judgments and this appeal has a much wider impact. But on the starting point, our ground one, on the judge's approach, our reading of her judgment, when she says she's taking a Sadler approach, was applying to the overall award, is the overall award just fair and reasonable? And that offends the 3.8 prohibition on, there's no question of whether the whiplash element is just, fair and reasonable. That doesn't apply to that. So we say her approach fundamentally on the valuation was wrong. To apply is the overall award just, fair and reasonable when there's a fixed tariff element to it is wrong, and that's what we identify as ground one in both appeals.
So the short point is this, is it? That if she wants to step back and look at the award, the only one that can be reduced is the non-tariff award.
Agreed.
I mean no disrespect, but when one comes to read the judgment in the second case, Briggs, the point is made rather more firmly by the defendant. You cannot touch the non-tariff awarding picked up by the judge. Is that fair?
Well, I don't think it is, my lady. I think there's two elements to that. In terms of the defendant, how the defendant pushes its case, it's always been that the tariff element is fixed and there's no flexibility on that, no movement. I think my lady's right that, and we can see it in the Briggs judgment if we need to, the district judge adds, I think it's the for avoidance of doubt.
Yes.
Were it not clear in Rabot, because she adopts the starting point of Rabot, she makes clear, doesn't she, that the adjustment is only to the non-tariff award. But in terms of, as in Rabot and in Briggs, but most obviously in Rabot, when the judge anchoring her decision overall in Sadler, we say took her down the wrong road of thinking, well, is the overall award just, fair and reasonable, harking back perhaps to what would have been awarded, leading to a disproportionate award in respect to the non-tariff. Because that's not a question a judge can ask any longer about the tariff element that is fixed.
Can I ask you my question? In Connolly, would it not have been equally acceptable as a matter of principle to have assessed the damages for the fractured ribs and then add in for the whiplash?
In Connolly, you
could have done it.
You could have.
Wrong in principle. You could have done it.
Insofar as the principle is to produce a figure that represents just, fair and reasonable compensation. Therefore, the Sadler and Duro aren't prescriptive as to a method that has to be followed.
No.
One could have started with the ribs.
But you took us to Connolly, as I understood it, to support a submission that the common law would have looked at the whiplash first. I would respectfully suggest that it doesn't say anything of the kind. It just happens to be how it was approached in that particular case.
But no, I did, my lord, I didn't take you to Connolly to demonstrate any point of principle. I took you to Connolly because within the judgment on Connolly, there's no consideration of principle. It's the application of the principled analysis that had been undertaken in the bulk of the judgment on was it appropriate to increase PSLA damages beyond inflation, and if so, where did they go to? But on the individual case, it was an illustration of the defendant's approach, what we say is appropriate at common law, or in a common law assessment. But in terms
so
of...
Why could the DJ in this case not have said, well, I'm going to start with the knee, and then I will take into account the fact there's a whiplash as well?
Well, because whilst the authorities don't oblige the court to start with the most serious injury, Duro, illustrating the sort of realistic and sensible approaches that a judge might take, one of those is to start with the most serious injury and identify a figure for that, and then to make such allowance for the additional as is appropriate.
But I don't think you've answered my question. Why would it be wrong in principle for the DJ or the judge in this case, in Rabot, to have started with the knee and then taken into account the tariff?
Because if the district judge started with a figure for the knee without any adjustment, then we lead into double counting.
Well, speaking entirely for myself, I would allow for the prospect of an adjustment. But why at the moment, I can't see why it would be wrong in principle for the judge to have said, well, I think it should be 3,000 for the knee, but I've got to take into account that there's also the whiplash, and I'm going to make an adjustment to make sure that I reach a result which reflects the combined effect of the injuries.
Well, it wouldn't be wrong, but
Thank you.
It-
Well, that's all I'm asking.
well, but just to expand upon that, and the reason I give you that answer is because it's just reversing the approach that we say that needs to be taken. So that we're all agreed that the tariff element is fixed, that there is, my lord has indicated, subject to what he hears from others, that the scope for adjustment for reduction to the non-tariff to reflect overlap. If that is right, then it starts with, it's the same ingredients and the same exercise, just in a different sequence. Because my lord, starting with the knee and adjusting that to reflect overlap, and that the pain, suffering and loss of amenity attributable to the whiplash injuries impacts upon and has to be reflected in adjustment to the non-tariff, is simply the other way round of doing what we suggest is the
But
correct
that has
approach.
the effect of treating the concurrently caused injury, pain, suffering and loss of immunity as being solely attributable to the whiplash. How can that be right?
But in our submission it doesn't, because we've acknowledged that where, to the extent that, and this is the evaluative judgment that applies assessing the non-tariff, to an extent those factors were contributed to by the non-tariff injuries. For the period of the injuries, to an extent, that the notional figure for the knee injury has to be adjusted to recognise and reflect that overlap. So there is compensation for its effects, but taking into account that the claimant is already being compensated for those same effects, albeit to the extent of...
Hasn't already been compensated. You've got an element of the overall compensation. I may be being very, very slow, but I do not at the moment understand how you can accept that the non-tariff injury must be assessed by reference to common law principles, and yet limit the damages for the concurrently caused pain, suffering and loss of immunity to whatever sum happens to be in the tariff award. I just don't see how you get there.
Well, because the court is concerned in producing an overall award. So at 3.8 it talks about producing an award of damages which reflects the combined effects of the injuries. The tariff element compensates the claimant for the pain, suffering and loss of immunity attributable to the whiplash injuries. I don't think that's controversial. I think accepted by all parties that is what it does. To the extent that there is, to compensate the claimant for the same loss of amenity within the non-tariff would be double counting. It would offend the principle of 100% compensation because it would represent overcompensation. The claimant's been compensated to the extent that that loss of amenity was caused by the whiplash injuries. It's going to be, if you don't make an adjustment, there's going to be compensation for the very same loss of amenity. Sitting within the common law element of this exercise, that offends double counting. It results in overcompensation.
Well, that's why, speaking for myself, I would allow for an adjustment. But the adjustment should be, if you accept that for a non-tariff injury a person should be entitled to recover their common law damages, the adjustment should be some notional sum by reference to what small figure may be in the tariff award for the whiplash. Because otherwise you undercompensate by reference to common law principles for the non-whiplash injury.
Well, the goal of the assessment is to produce, in respect to the non-tariff, an award which is just, fair and reasonable. Whatever approach you would take should lead to that outcome. Everybody agrees that that's the touchstone before and now for that element of the exercise. In order, the route by which the judge gets to that is insofar as it's a common law assessment, one that preserves the options that were identified in Juro, in Sadler, whatever represents the correct approach. We say as a matter of practicality and for disciplined assessment, as in Juro, the whiplash in this category of case is the most serious. It represents the starting point, and then the judge makes an allowance to the extent that they consider appropriate to reflect what is over and above the consequences of the whiplash injury.
I mean, the key question really is, what does section 3.8 tell you to do? And it seems to me very difficult to interpret that section as telling you anything.
Well, and that's part of our case manual. 3.8 doesn't mandate an approach. It doesn't tell a judge or a court what it must do, save for the parentheses that any assessment must be subject to the regulations. But it simply...
Any assessment of the whiplash must be subject to the regulations.
Yes, but the whiplash element, because by definition, the gateway to 3.8 is a combination of whiplash and non-whiplash. And the whiplash element of the award must be, is subject to the limits imposed by the regulations. But in terms of what 3.8 does, it says nothing within the section prevents the court making an award that reflects the combined effects.
It doesn't prevent you standing back.
No, it doesn't prevent you standing back.
That's probably what it says.
It doesn't prevent you standing back. It doesn't prevent you. It doesn't prevent you. Lord Justice Pitchford, as we talk about combined effects, there were really three scenarios. Where there's overlap, clearly there should be reduction as part of the stepping back overall exercise. If there is, my learned friend says, the synergistic effect, where the combined effects are greater than the individual components, as unusual as that is, there may be an increase to the non-tariff. One would have to accept that. That must be the corollary of our argument. And there may be, not here, but those, as he says, minority cases where it is simple aggregation, there is no adjustment. But in the majority of cases, in these cases on the appeal, adjustment is necessary, adjustment is appropriate, adjustment to reach a fair and reasonable allowance for the non-tariff doesn't offend 3.8. Conversely, an exercise in simple aggregation with no regard to what's compensated by the tariff award or comes within the tariff injury, we say offends the common law and is a leap. There is a chasm between what 3.8 says and the argument that it mandates the approach the interveners contend for, which is, in every case, it's pure simple aggregation. That's the claimant's primary position. You don't have regard to overlap. You don't have regard to the fact that the tariff injuries are compensated in full by the tariff award. You assess the knee injury in our example in isolation, and regardless of overlap, you simply aggregate the awards. That's not what flows from 3.8. And insofar as Parliament was aware, presumption A from the intervener, of what the common law was, that argument means that Parliament has proposed a model of simple aggregation which, as Lord Justice Pitchford made clear, would only be appropriate in the minority of cases.
And if you accept, I think, their assumption B or C, which is that this Parliament has only changed the common law so far as is necessary, then you end up at a position where you replicate Sadler or whichever particular approach. There's any number of ways of skinning the cat, but you look at it overall and you make such adjustments as are necessary. The only difference is that instead of getting notionally £3,000 for your whiplash, you've been told it's going to be £1,500 or whatever the sum may be.
Yes.
So you just do the same exercise, and you may have to. You don't do pure and simple aggregation, but you don't artificially depress the common law damages for the non-tariff award.
No, and we're not suggesting that you should artificially depress for the tariff award. That it is, as we see in Connolly, it is, and much more serious injuries than we have in any of these appeals. If you RPI the allowance of, say, £500, for those injuries with a Castle's 10% uplift. It's £1,100 at today's money. But the increase here, it has always been the case that where there is an obviously more serious injury, which is the dominant factor in terms of pain, suffering and loss of amenity, the uplift is for those other modest injuries is modest. It is in the order that we submit is appropriate in these appeals. It's not the £2,500 or anything like that the district judge allowed. And in terms of my Lord's point
well,
of...
I mean, is the question, I've written down what I think the question in the case is, and tell me if I'm right, whether the pain, suffering, loss and amenity concurrently caused by both whiplash and other injuries is to be compensated either, one, only by the small part of the tariff allowed for it, or two, by the normal common law compensation, or three, by something in between. And you say one, Mr. Williams says two, or three, and Mr. Ware says two.
Yes, but
No? Wrong question?
no, it captures the issue.
Yeah. And it's quite difficult, isn't it? Because you say anything but one is double compensation contrary to the legislation, contrary to the purpose of the legislation.
Well, it's contrary to the common law, insofar as that common law is unaffected by the limited inroad of fixing the tariff element.
Why is it contrary to the common law? I would have said it's contrary. I mean, what my Lord's been putting to you is that anything but two or three is contrary to the common law.
But any approach, I thought my Lord's introduction was on the double counting. Any approach that facilitates
Well, he says
compensation
three
for
allows
both.
you to stop double counting.
I mean, you'll see.
You'll see.
Yeah. At the moment, provisionally, without in any way having made up my mind, of course.
Our position is that in respect to the non-tariff, we accept that there will be a common law assessment of that element.
What's the point if it's one?
Because the non-tariff has to be assessed at common law.
Why?
The non-tariff element.
Oh, sorry, the non.
The non-tariff.
No, but what's the point of assessing the concurrently caused pain, suffering and loss and amenity at common law when it's already compensated by the tariff?
Well, because insofar as...
I mean, she made a very helpful finding
Yes,
for us in Rabot or Rabot.
and the same finding in Briggs, or very similar.
Yeah, a very helpful finding, which was there was no additional loss of amenity. So the only thing extra was the pain caused by the knee in Rabot. I can't remember what the other injury was.
It's just the knees, Mark.
Both knees, yeah. So the only additional amount was a pain in the knee, and she assessed that, and you say she assessed it on the wrong principles, but anyway, she gave quite a relatively large sum for it, and you say it should be smaller. But leaving that question aside, once she's done what she's done, you're happy with it, that she is not double compensating for loss of amenity of the caused by the whiplash.
On the district judge's findings, if she had followed that through and made clear that, because there's no loss of amenity attributable, I'm only compensating for pain and suffering, and that was very modest, then the figure would be lower and we wouldn't have a complaint about that.
Yeah. Yeah. So I mean, the figures don't really matter for the millions of cases that stand behind this one.
Yes.
What matters is the principle.
Yes.
And you say you cannot be compensated twice for concurrently caused pain, suffering, loss, and amenity, and if that's included in the whiplash, then that's all you get. Tuppence. You get a very smaller part of £500. That's it.
Yes. Insofar as, and we focus in our submissions on, the inquiry is focused upon, well, what is additional? What is there that goes over and above what is compensated within the tariff award? And it's the focus on that, and that's the compensation that goes into the non-tariff.
But that does involve the process my lady was asking you about earlier, which is undertaking an evidential analysis of what pain, suffering, loss and amenity was caused by the whiplash, which the whole purpose of the official injury portal is to prevent happening at all.
But if in order to undertake the non-tariff assessment, but by definition, the judge will be presenting, if the case doesn't settle, the judge is going to have to make factual findings as to the non-tariff injuries, extent of symptoms, severity of symptoms, impact of symptoms for those non-tariff injuries. Without those findings, there couldn't be an award. You're right that we suggest that in order to reach those findings, the judge has to be clear in their own mind as to the extent to which pain, suffering and loss of immunity was attributable to the whiplash injury. You can't get to one, you can't focus on, as the judge has to, on the non-tariff injuries without an appreciation, and we say findings, as to the impact of the whiplash injury. So it's a case in which the judge is going to have to make factual findings for the non-tariff element of the award. The extension is, in the mixed injury case, findings in relation to the whiplash are required.
The difficulty is, forgive me, I am going back.
I suspect this is only one of my difficulties.
It's the point that the Master of the Rolls has just referred to. This hearing and the whole process isn't directed to exactly that type of exercise, because as I understand it, and I will be corrected on this is focused very much on a paper exercise rather than oral evidence being given.
Agreed?
These are limited medical reports that are not a reflection on the expertise of the doctor, it's simply the way they're paid and formulated. So therefore there is limited information available to the judge in a busy daytime list as to how to make that assessment, and it's a critical assessment.
But whilst it's limited, it has to be sufficient.
Well, it's also got to be fair. And how do you make it fair if it's based on limited information?
Well, the legislation, the procedural rules and the practice direction that support it have dictate that the arena and the process for the determination of these cases is before the district judge in the circumstances that we have here. In terms of the fairness, those rules include procedural fairness. The claimant obtains a medical report, the claimant puts in such material as the claimant wishes to, and the judge will form a view on that material with the claimant able to put in whatever is considered necessary and can upload what is necessary. Where there is a mixed injury case, the non-tariff assessment will be based upon that material. I don't follow as to why it is unfair to the claimant to suggest that in reaching a decision as to what is just, fair and reasonable, the judge takes account of the whiplash injuries, which are also addressed in similar terms in the same medical report. That report, and it's only authorised medical practitioners who are and registered who are allowed to produce these reports, must address the impact of the non-tariff injuries. Without that, the claimant won't be in a position to properly pursue their claim for the non-tariff element of the award. So it doesn't lead to unfairness, in my respectful submission, to suggest that the judge, when making findings as to the impact of the non-tariff, similarly makes findings as to the tariff.
Can I just ask you what I think is a follow-up to that? You're here as a sort of representative of the pragmatic, others would say, sitting on the other side of the court would say, cynical defendant's approach. But just adopting the pragmatic approach at the moment, aren't you going to generate a new industry and knee claims?
Well, it might be said that the whiplash reforms in themselves have created a new industry and knee claims, because that is...
Well, that's my point. Because I come back to something I asked you a while ago, which I would be grateful if you just think about for a moment. You can't force someone to bring a whiplash claim. And if you're right, you are going to have a number of frequent cases, particularly if you always take the whiplash first, where the aggregate compensation for whiplash and non-whiplash injuries are lower than the compensation that would be given if it was only for a claim for the non-whiplash injury. And that seems to me to be A, counterintuitive, but B, probably undesirable.
The claimant can't be forced to bring a claim for whiplash injury, but the claimant is required to sign a statement of truth on the claim notification form.
That's fine.
Setting out.
I'm just claiming for my knee.
No, but the claimant's asked, and the medical expert will ask what injuries were sustained. The claimant can't conceal that he's suffered a whiplash.
And you can say, I sustained a whiplash, but I don't want to claim for it.
This may be a problem with the legislation. I mean,
maybe the government achieving its objective. There'll be no more whiplash claims.
But well, to piggyback what the Master of the Rolls has said, it is that might be a consequence. The cynic might say that the claims industry finds a way to navigate around hurdles that are imposed in terms of recovery of damages or costs, and was ever thus. But in terms of what is the correct approach, that might be an unintended and unwelcome consequence, doesn't distort the fundamental analysis. What is the correct approach?
Do counsel normally turn up on these things, or were these cases being set up for a test case from the start?
If it gets to a hearing like this, certainly on one side, one would expect on behalf of the compensator, counsel to attend for a hearing. And as we see here, these claimants were represented from the outset.
Yes.
They do in Birkenhead.
Yes.
Because I actually attended a whole afternoon of stage 3s in Birkenhead.
You're not the first Court of Appeal judge to observe what goes on at Birkenhead.
No, it's a very good court.
But in terms of representation, I am told that, and others in the court and perhaps more regularly in this arena, that both sides are regularly represented.
They're often represented.
Often. Because, and again, and so in terms of fairness...
But I mean, it's very interesting. I mean, just, this is an aside, but it's important. There have been 350,000 cases go through the whiplash portal thus far, I believe, something like that. And it was intended that 100% of them should be represented by nobody and that they should just go through. But in fact, 90% of the claimants have been represented by somebody. But very few have come out the other end and gone to court thus far. But some do, and when they do, as you say, they're often represented. But it's intended to be a simple exercise. I mean, one of the things that I, for my part, would find helpful in the limited time you've got is if you could address the practical realities of the, in terms of making the job doable of the competing solutions. Because your solution actually is perhaps, well, I leave it to you. I mean, I can see arguments for saying your solution is doable, but of course, Mr. Weir's solution is easy peasy, he would say. He's going to say.
He has said and will say.
Yes.
But ours isn't, in our submission, complex or the three-step analysis that we give.
What if you don't know? I mean, this is a simple case, Rabot. Well, both of them are simple cases. You know that the additional injury to the whiplash didn't cause any other PSLA. But what if you don't? And what if the causation issues are complex, which is, I mean, you know, my colleagues will tell me, but I mean, I'm not an expert in this field, as everybody in court will know, but it strikes me that it would be common for the causation issues to be complex. They are in every other area of law.
But in simple accidents of this nature, they are a rarity to have any complex causation arguments. That somebody suffered a road traffic accident, contemporaneous recording of attendance at hospital with symptoms, exactly what we see here. There's no complexity to causation here. It would be the exception rather than the rule that a pre-existing underlying condition, for example, might feature in terms of, well, to what extent are the symptoms attributable to that, as opposed to the effects of the accident.
But it would not be the exception for there to be concurrently caused pain, suffering and loss of immunity of a greater or lesser extent, as we've got in these cases.
No, it wouldn't.
So
But
that's why I've been focusing relentlessly on concurrently caused PSLA.
I understand,
what
but
this case is all about.
Responding to my Lord's point about, well, in terms of approach, what about complexity? These are straightforward claims. The overwhelming majority are. These are. There's nothing. It's not as though. In court, there are members of the steering group who have been looking for test cases. That the view is that an April and masses intervention. These are appropriate exemplars of the sort of cases that the district judges and deputy district judges are facing as a basis for this court to look at the issues of principle. And there is no complexity to it here.
So you say, I mean, it's all, I mean, I think you contend for what, £400 or £500 for the addition for the knee. You say anything more would be ridiculous because the knee really is caused exactly the same pain, suffering and loss of amenity. Loss of amenity, but a little more pain and suffering because you've got a bad knee as well as a bad back.
Yep.
But, you know, if you take paracetamol, the paracetamol doesn't discriminate between the back and the knee. And so the pain disappears in both if that's good enough, pain relief. And it's inconvenient, but not much more than that. And it would be ridiculous to give common law damages of £3,000 when statute has said you only get £500 if you get the same consequences of a bad back.
Yes, but it's even at common law, it wouldn't be for those sort of, you know, in a whiplash claim historically, Connolly being an example.
You would have got 3,000 quid.
You'd have got your 3,000. Now you get your
500.
Let's say 1,500. I don't know what the maximum figure for the 2 years is, but whatever it is, in Briggs it was I think 1,390 at 10 months duration. But you get that figure. And then you get an allowance as is appropriate. As my Lord says, that the impact of the knee over and above that was minimal. At 8 weeks post-accident, the pain score was 2 to 3 for that versus 8 to 9 for the whiplash. If you're looking at inability to
you say it just makes no sense.
It makes no sense. If you're looking at, well, I think in these cases, couldn't take the bins out, had difficulty bending down, stiff when waking up in the morning. The whiplash injuries, which were much more severe, of longer duration, more disabling, they account for all of that. The impact of the knee injuries here was minimal. The judge can make those findings. They're the findings that are required to be made, and they translate into a modest, appropriate, fair and reasonable allowance for the additional impact.
Am I allowed to ask how much Mr. Rabot would have got on common law principles for his whiplash?
It's not something anybody's ever had to look at. We in our skeleton, I think we give you a table to show
The
comparability. So, without descending into his individual case.
Because your last submission is fine, but it's all predicated on, it's all skewed by the fact that the award is not a common law award. It's been deemed to be appropriate and proportionate by the government, and that's all fully explained. But we've got a slight out of syncness between the courts and the government about what appropriate levels of compensation are.
But then...
Which we're bound by.
Yes.
On whiplash, but we're not bound by on the others.
No, agreed.
We're subject to the meaning of section
3.8.
Because if you read the claimant's skeleton argument, you'll be forgiven for asking what the meaning of the words subject to the limits imposed by regulations are. what weight is given to those.
And equally, one would be forgiven on the intervener's approach. How is it that the words of 3.8 take us to a position of you get compensation for the effects of both injuries, even when they overlap, even when they're identical, even when, as here, the contribution of the non-tariff is minimal, you just get a pain, suffering, loss of immunity award for the non-tariff, assessed in a vacuum, that's just added to the whiplash. It makes no sense and doesn't arise from a statute and is inconsistent with the common law.
And it makes standing back very difficult. It makes the standing back exercise very difficult because you don't know whether you're standing back to decide to, if you like, give effect to a wider policy of the statute, or you're standing back to give effect to a wider policy of the common law.
But the standing back only bites on the common law element. There can be no standing back on the tariff. And whilst we disagree with her fundamental starting point, and we disagree with the figures that the learned district judge arrived at, it's not said by her that this was an impossible or overly challenging exercise to form a view as to the extent to which pain, suffering and loss of immunity was attributable to one or other. And this is a district judge tackling this exercise without the benefit of such guidance as this court gives on the essential.
It'll be much more difficult afterwards.
But on the essential of making the necessary findings and articulating and identifying the extent to which attributable to non-tariff or tariff, she gives us, and one would expect that with encouragement to medical experts to provide the necessary information, which is straightforward and simple, that other district judges would follow her lead, and it's not a new approach. It's making the findings that judges in the small claims arena, assessing claims at this level, have always had to make.
It's a new approach because you're combining two different things. You're combining, in effect, a statutory award and a common law award. That is the fundamental difference.
Well, it is, my lady, but it's the same exercise. It's just that the tariff element, the whiplash element, rather than the product of judicial evaluation a la Connolly, is now fixed. But you are blending together and you are focusing on the non-tariff, what is just fair and reasonable for the consequences of that injury.
If you give the non-tariff common law damages, the only double counting is whatever small figure there happens to be within the tariff award for the overlapping concurrently caused pain, suffering and loss of immunity, which is not very much because the tariff award is very small.
Sorry, Lord, can you just repeat that?
If you give for the non-tariff injury common law damages, or if you assess common law damages, and if you were then to simply aggregate the common law damages and the tariff award, the only double counting would be whatever small sum there is in the tariff award for the concurrently caused pain, suffering and loss of immunity.
But respectfully, it's wrong to think about what the number is within that award. What the number is for loss of immunity within there, in my submission, it isn't the focus. It is, if you concentrate on the fact that, to the extent that there's pain, suffering and loss of immunity attributable to the whiplash, that is compensated in full by the tariff award. Whatever, and I don't think we see in any of the memoranda anything that indicates what the thinking was for individual strands, which we wouldn't see in a common law assessment. So to try and second guess or work out what element has been allowed for that takes you down the wrong road. It's the wrong element.
To my mind, what you haven't dealt with in your very helpful submissions is the suggestion that adopting your approach treats concurrently caused pain, suffering, loss of immunity as if it was solely caused by the whiplash. That for me is something which I can't see my way through at the moment.
But to the extent that that is caused by the whiplash, that's compensated in full by the tariff award.
You're immediately using the language of it being caused by the whiplash, where in fact it's concurrently caused. There are three. We've been over this.
But we have. But obviously it's bothering my lord, and so hopefully I'm not at risk of repetition becoming irritating. But to try and answer it and to grapple with the challenge, that's why we say, in making the award for the non-tariff element, the judge focuses on the extent to which that is responsible for pain, suffering, loss of amenity that goes beyond, as the district judge acknowledges here, goes beyond what is compensated by the tariff element. And I think it's right to think about how district judges would analyse the Rabot or the Briggs case and look at them, because the judge here made, in many respects, the findings that were necessary. She reached a conclusion as to the extent to which loss of amenity in particular, but also the pain suffering, was attributable to one or the other, which then informs the assessment. Under common law, there isn't the parcelling out of, well, what figure have I allowed for loss of amenity here and loss of amenity there? Where there is overlap, where there's concurrent, there's adjustment to your additional injuries, the lesser injuries, to reflect that it's already been compensated by the main injury. So a la Connolly. To the extent that the fractured ribs in the chest added to the claimant's loss of amenity, that was captured in the additional allowance. It seems to be approximately £500 over and above the whiplash. And that's what we suggest should happen here.
You may be right.
I'd like to think I am. Your reaction suggests I might not. But in terms of coming back to, I think we started this with my lord in terms of simplicity of approach. In the mixed injury case, the only departure, because I don't think either of my learned friends would say, it's not necessary for the judge to have materials to make findings of fact as to severity, duration, impact of the non-tariff. In terms of the tariff, there certainly has to be evidence as to duration. Without that, the judge couldn't determine what the tariff award is, the parties wouldn't know what it was. So what is it that we are suggesting over above, evidentially, the sort of narrative that you don't have them, but if we need to produce them and it'll help the court, the original medical record, the reports, didn't just give duration for the whiplash injuries. It described, as I've said, pain severity at particular points, the acute phase, the 8-week phase at the date of assessment. There's a description of range of movement, for example, associated with that. Now, on a strict application of the tariff, one would say, not essential. Just tell us how long you had whiplash symptoms. But the doctors here are already providing the sort of information that's required. Missing piece of a jigsaw, perhaps a view or a helpful piece for the jigsaw would be a view as to the extent to which it's attributable to one injury or others. But that material is there. So in terms of at the hearing, the only add-on from our approach is, rather than simply say what the duration of whiplash is, and nothing more, and then turn to the non-tariff, is to make findings as to not only duration, but severity and impact. And so given that it's the minority of cases, even on the numbers that we have, that are making it to judicial assessment, it shouldn't become a burden to the busy district judges list. They're having to make, if it's a case that's before them, they've got to make factual findings on the non-tariff. It's simply an addition to that, flowing from the very same medical report, which at the moment has the necessary ingredients, but perhaps could be improved when, following the decision in these appeals, all stakeholders. Sorry.
Which decision?
Following the decision in these appeals. In terms
Oh, these
of
appeals, I'm sorry.
Sorry, in these appeals, what is the correct approach will then focus the minds of stakeholders and solicitors asking for medical reports as what needs to be included. The evolution or the extension beyond what their approach requires is minimal. but eliminates overcompensation and gets the court further towards producing an award which is just, fair and reasonable. Yes, in fact, can we take Rabot, so supplementary bundle, Rabot electronic, bottom right 20, electronically page 20, my lord, please. It's behind divider 4. And so, rather than promising that if it would help to produce the report, we have the medical report here that was in Rabot. So starting at 20, and so at page 23, the medical, and this is a fixed fee medical report of the type routinely provided. So at page 23, there's a summary, and there's the prognosis that gives the sort of duration of symptoms with the bullet point breakdown. We've got, as my lady would expect to see if we were at common law, well, what's the claimant's previous medical history? Does that impact upon extent of injury or attribution? At 25, a narrative as to the accident circumstances. And then at 26, I've been given the court the headlines from this. But one sees there the onset of injuries, the severity of injuries in the acute phase, which is halfway down the page. Then there's progression of the injuries, the neck, the low back, the knees, and the travel anxiety. We can see there, in relative terms, and one can see why the district judge reached the conclusions that she did as to the minimal role of the knee injuries against that. At 27, there's treatment received. 28, the amenity aspect, effect on hobbies, lifestyle, and support. I think, as I've said, the only effect on domestic duties was moving out the bins. Then current symptoms as at the date of examination. I'll be corrected. I think this is approximately 2.5 months. Thanks, Ben. So query a nudge on from that 8 weeks. We can see at that point the comparison or the relative impact of neck, low back, travel anxiety versus the knees. And then, in fact, I can't remember if this was a remote assessment or in person.
It was remote.
I'm grateful, my lady.
So no examination.
No hands-on, but there was demonstration by the claimant as to
Flexion.
yes,
Exactly.
range of movement and so on and so forth. Now, just pausing here, this is the sort of report that solicitors are asking for and are obtaining, that experts are producing an appropriately detailed response. It's not as though it's a 2-page letter that says, whiplash 10 months, knee 4 months. So in our respectful submission, coming back to my lady's point about evidentially, does this sort of material provide a fair and appropriate platform for negotiation between the parties or assessment by the judge for the findings that we suggest are required? In our submission, it does. And again, in terms of, well, is there a...
The one thing it doesn't do, it's absolutely fine for the whiplash element and for feeding into the tariff. The one thing it doesn't do is to give any guidance or opinion about the extent of concurrently caused problems.
Well, 2 things. One, the material that the expert did provide was sufficient for the judge to reach the conclusion that she did, and there's no challenge to that conclusion.
Yeah.
So, whilst...
No, but I'm just talking about the quality of the report, which is fine for everyday purposes. But what it doesn't do is address the particular question that we're talking about. She made her findings, but as a matter of fact, it doesn't.
Well, there's 3 elements to that. One, it's the judge's findings that principally matter as opposed to the view of the medical expert. Question 2, did the expert provide sufficient material and reasoned analysis to enable the judge to reach the findings that she did? Plainly, yes. No challenge to that finding. Might there be a step forwards in these medical reports to ask that question? that in the mixed injury case, asking the expert, and I think in our response skeleton argument, we suggested this might be an opportunity for, and I know the court would never wish to be prescriptive or dictate what has to be included, but the value of that sort of expression of opinion would assist the parties to facilitate settlement without going to a final hearing, but also would assist even further the district judge. And where you have a medical expert who's analysed the impact of the individual injuries in that way, it's not a difficult or complex addition to it, is it, Mark?
It's another sentence or two.
Exactly. And it nails the challenge that we have here in the multiple injury. And it might be that they say there is no overlap. And so I'm trying to...
The knee stopped him playing badminton. The whiplash stopped him putting the bins out, as it were.
We could think of a sport where it's dependent upon your upper limb function as opposed to lower limb. That the injury to the knee has had no impact upon his ability to play
Chess.
whatever. Chess. I was thinking more shuffleboard, my lord, but we'll go with chess. But therefore there is none there. Therefore it'd be wrong to attribute that significant loss of immunity
Golf,
to the knee.
there are hundreds of people on the courses as we speak with dicky knees.
Yes. Dicky knees, dicky hips, dicky ankles.
If their shoulders aren't working,
Then they can't play.
Yeah.
And so it's no greater challenge than that. And that sort of indication then, in terms of simplicity, is a minor add-on to the sort of reports we've got here. And we can go to Briggs as well if we need to. It's in similar vein.
I mean, is there anything else you can tell us in relation, by way of submission, in relation to the $64,000 question, which is why concurrently caused pain, suffering, loss and amenity should only be compensated by the little amount in the whiplash tariff?
Having departed probably from page 1 or 2 of my notes at an early stage, can I just remind myself as to the remainder?
That seems to be a question.
You just put it better.
I suppose only that, and it's not done forensically, but for the claimants, they say there's no scope for adjustment. It's simple aggregation. There's no scope for, as my lord has identified, the possibility of adjustment where there is overlap. What they then say on the district judge's approach, they would accept that her approach, recognising adjustment for overlap, would be correct. So, and that approach, I think if we turn up what my learned friend Mr. Williams has to say, I've worked from his skeleton in the core bundle, starting with Rabot. But if we just turn up that, please, it's page 37 in the Rabot core bundle.
We're looking at the intervener's skeleton.
No, Mr. Williams, the claimant.
Mr. Williams, yeah.
The Lord will remember that Mr. Williams identifies primary approach, secondary approach, and then the defendant's approach. But if we turn to, and his primary approach is no adjustment whatsoever. They're wholly separate exercises on completely different tracks, and you just add them together. But then the second approach, aggregation with a totality adjustment. Page 46, please.
Which paragraph in the skeleton?
Paragraph 29, it starts at. So if the primary approach is rejected, then they say the approach taken by the district judge is to be preferred over that now proposed the defendants. And what I want to highlight is, he goes through a series of elements which he says support the district judge's approach. Our approach mirrors and meets all of these. So, first of all, it entails the determination of whiplash damages in accordance with the statutory tariff. That's precisely what the defendant's approach does. And then, so as a follow-on, assessment of the non-whiplash damages in accordance with the common law principles which the Act provides. Our approach. An adjustment of the latter in accordance with Sadler to take account of the suffering and loss of his amenity which are common to both the whiplash and the non-whiplash, is then perfectly rational. Precisely the submission that we make and have made this morning. And then his last sentence, it is also consistent with section 3.8 of the Act above, which permits the court to make an award of general damages reflecting the combined effect of a claimant's whiplash and non-whiplash injuries. So pausing there, if the claimant's primary approach of simple aggregation without regard to overlap is rejected, then that paragraph there, although directed towards the district judge, mirrors precisely the approach that we proposed in the skeleton and have pursued this morning.
Not quite.
Pardon?
It's a slightly bendy mirror, because the difference between you is that they say that, if you like, the common law award holds sway, subject to a slight adjustment for what's in the tariff award, whereas you say the tariff award holds sway, and you don't have any, you effectively remove any possibility of overlap in the way you've described. So that, although what you've read is pretty close to what you're saying, lurking underneath it is the real difference between you.
But if one steps to the what his tests were as to the appropriateness of an approach, whiplash by reference to tariff, non-tariff by reference to common law, adjustment a la Sadler is perfectly rational, which is what we contend for, and the acceptance that it is what's his phrase, consistent with the language of 3.8. Now, my lord is right that lurking beneath is, well, where do you start and how do you do it? But in terms of the merits and as a matter of principle, is our approach.
No, the matter of principle is the one I've been banging on about the whole day. The matter of principle is whether tariff or common law holds sway for concurrently caused pain, suffering, loss, and amenity. And, you know, that is the question. And you say, obviously, the statute holds priority.
But the regulations, yes, represent that fixed starting point.
You say anything else would be double counting. They say the proper interpretation of 3.8 is that you still get common law damages for other injuries. We've got to pay our money and take our choice.
On your $64,000 question, can I just check if there's anything else we need to look at?
I think the defendant would say they pay money.
Do my lords and my lady have any other questions or concerns?
Not at the moment.
Concerns, not, no, concerns.
Well, if there's anything else.
No, thank you very much, Mr. Allen.
Thank you.
Mr. Williams.
Yes, may it please your lordships, my lady. If I can perhaps go back to the debate between my learned friend and my Lord Justice Stuart-Smith about the Connolly case. In our submission, it's quite an exposing discussion. It has the wrong starting point, as my Lord observed, because it's talking about a different exercise. Connolly is about merging two common law awards, and we're of course here concerned with the difficulty that arises when you're merging a common law award with a breach of statute, which is sui generis. But if you look at Connolly, and I think this was reflected in some of the observations from my Lord, the result would have been the same if that court had started with the fractured ribs and then fractured the neck injury. That had come to the same figure. And that's where you expose the difference. Because if in this case, let's just take the Rabot case as everybody seems to be doing, if you take that as the starting point, if you, in that case, started with the knees, you'll start at 2,500. But then according to the defendant, you add the whiplash, and it doesn't merely add very little, it doesn't merely add nothing, it actually somehow reduces the £2,500 which the claimant gets for his knees alone. And on the defendant's primary case, reduces the compensation to £1,855. And we say immediately that's an outcome that is impossible to understand in circumstances where the statute, which really is the beginning and the end in our submission of this argument, when the statute deliberately eschews having any impact whatsoever on the assessment of any damages other than damages for whiplash, or if it's present, a minor psychological overlay as well. If my learned friend is right, then the claimant in Rabot gets less than if he had just suffered a knee injury, or if he had decided only to claim for his knee injury, or if, to use a silly but not completely fanciful example, if on getting out of his car to exchange details with the other driver, he had tripped on a defective paving stone and fallen to his knees and bruised them, on the hypothesis that the car accident only caused neck injury. And so radically different sums are recovered in respect of the knee injury because of the happenstance that it was suffered simultaneously with a neck injury and a back injury, but in circumstances where the statute doesn't impact at all on the assessment of knee injuries. And in our respectful submission...
It doesn't say that.
Forgive me?
The statute doesn't say it has no effect.
Well, obviously I'm going to come to what the statute says very shortly, but that in my respectful submission, just at the outset, is something which exposes, in my respectful submission, a fallacy in my learned friend's case. Because it is impossible to see, if we're right, how the statute can impact upon the assessment of damages, which, when the only suppression it makes of common law principles, is specifically in the context of the whiplash type injuries. Now, before I come to the statute, can I also perhaps confront the point that my Lord the Master of the Rolls was putting, as it were, as an encapsulation of my learned friend's argument? Well, you say that this leads to absurdity because you get a more serious whiplash injury, and you've then got a less serious knee injury, adding a much more substantial amount of money. And I recognise that is what happens. But that isn't the outcome, in our respectful submission of our case, being absurd. It is the outcome of Parliament having made an extremely targeted intervention only into one aspect of the assessment of general damages for personal injuries. So Parliament has suppressed whiplash injuries, but hasn't suppressed anything else. It hasn't followed Lord Scarman's advice in the Lim Par-Chu case, which is that if there's to be a modification of the common law, it needs to be systemic. And it has simply tinkered with one subset of the whiplash injury market, as it were. And now I recognise, of course, it's a very large subset because there's so many whiplash injuries. But the fact remains that in terms of its intervention in the common law, it is extraordinarily narrow. It's not even all whiplash injuries. As we know, it doesn't affect motorcyclists or cyclists or pedestrians. It doesn't affect injuries of more than 2 years. And it doesn't affect whiplash injuries, which are actually part of the larger injuries. So it's an extremely targeted intervention. And we see that also, as my learned friend Mr. Weir makes clear in his skeleton, with its intervention on the rules about settling claims on a pre-medical basis. That, again, is very targeted to whiplash injuries and anything else. So that is the focus of the statute. So if I can actually come to the statute, which is at page 8 of the combined authority bundle, just wanted to start subsection 3. Perhaps we ought to start off with subsection 1, actually, not subsection 2, because that obviously tells us the statutory compass. It applies in relation, the section applies to the determination by a court of damage of, I'll call it general damages as shorthand. Applies in relation to the determination of general damages where a person suffers a whiplash injury. So that opens the door. If there is a whiplash injury, the section applies. Subsection 2, which we have visited, then it specifies, essentially provides that the amount of damages, general damage for the whiplash, is specified by the Lord Chancellor. And that we can skip over the bits about mixed injuries, minor psychological injuries, and jump to the key subsection 8.
In section 3, just to address my Lord's earlier point, this legislation applies in a case, in relation to the determination by a court of damages, where a person suffers whiplash.
Yes.
So it's not open to the person to say, I'm not claiming for whiplash.
You can't sidestep the section because it applies if you have suffered a whiplash injury, and whether or not you have suffered a whiplash injury is a matter of fact.
Exactly.
But where, with respect, I would travel with on my Lord's path, as it were, always a welcome place to be striding. There is nothing, however, to stop a claimant saying, but I don't seek any compensation for my whiplash injury.
No.
If the circumstances of that would be that he actually gets less than he would otherwise get for his knee injury alone, if I take Rabot as a template. Because,
well, I think Mr. Allen's counter to that is to say, well, even if you don't claim in relation to the whiplash is such an elephant in the room that the court must assess the tariff award and then treat it as if you had claimed for whiplash. So he would, I think, say you don't avoid the problems by not pursuing the whiplash claim.
well, the answer I would suggest to that is that the Act doesn't really help you one way or the other as to whether it is conceptually possible to eschew being compensated in respect of a particular, no pun intended, limb of your injury. But I with respect to suggest that the mere fact one is even having this sort of angels on the head of a pin kind of debate is itself an indicator that something has gone wrong with the defendant's analysis, because we shouldn't be in a position where one is debating whether it is possible for a claimant to sacrifice his right of damages, because the inclusion of that right of damages would perversely lead to the suppression of his common law damages for his different injuries in circumstances where the statute is not addressing any injury other than a whiplash injury. So the very existence of the debate, in my respectful submission, is an indication that something is wrong in the defendant's analysis. But I mean, my answer would be that subsection 1 says this, that shows that you can't sidestep by not claiming for your whiplash, because it doesn't ask whether you're claiming, it asks whether you have suffered, and that is just a question of fact one way or the other. But that then simply leads you into subsection 2, and subsection 2 is the fixture of your amount of damages with reference to the specified tariff. Well, if you don't claim any damages in respect to your whiplash injury, then I would say that subsection 2 simply isn't engaged, and you're simply left with the common law assessment of your knee injury, or whatever it may be. Sorry, my lord, I think the Master of the Rolls took me back to subsection 3. Can I move onwards to subsection 8 now?
Yeah.
So if we get to subsection 8, and quickly, it makes it clear that it doesn't prevent the court from awarding an amount of general damages which reflects the combined effect of the person's injuries. Now, those opening words demonstrate, in our respectful submission, though there are other things that demonstrate as well, that qualifying whiplash injuries aside, no change is being made to the common law. But as I say, I would submit that one already gets that from the subsections we've already visited, subsection 1 and subsection 2, because they make it clear that the Act is directed only at the whiplash. As I've already suggested, so does the balance of the Act.
So why does it, you said that very quickly, but is that right? Why does it make clear that no change is being made, whiplash aside, to the common law?
Well, because subsection 1 is the threshold, and have you suffered whiplash? Subsection 2 is then the operative part. If the damages, the general damage for the whiplash is to be the specified amount, then subsections 3 and 4 deal with other specified amounts or an adjustment to the specified amounts if there are minor psychological injuries as well as a whiplash. But then there is nothing whatsoever which impacts upon the assessment of anything else. And
unless,
as I have,
unless 8 does.
well, of course I've got to come to 8, but and again putting it into the wider context of the statute as one must, and as Mr. Weir says in his skeleton, if one then gets to the next mischief at which the Act is directed, which is unevident settlements, you get that at subsection 6, page 10 of the bundle. That again is exclusively focused on whiplash claims. And I mean, I think there's some controversy at the bar as to whether or not it's appropriate to be looking at what Lord Wolfson has said in Parliament when no one suggested you're over the pepper and heart threshold. But even if you don't look at that, any of the travaux préparatoires, any of the explanatory notes, explanatory memoranda, nothing whatsoever to suggest that at any point there is an intention to modify anything except the way in which damages in whiplash cases are approached, in whiplash injury cases are approached, or whiplash plus minor psychological injury. So if I go back to subsection 8, so it says nothing prevents the court awarding an amount of general damages and where a person has suffered injuries in addition to the scheme injuries, as Mr. Weir calls them. And then the award of damages reflects the combined effect. And then that, of course, is subject to the rider, subject to the limits imposed by the regulations under this section. Now, that rider, in my submission, tells us two things. Firstly, it tells us that the sum of damages which reflects the combined effect is a sum which will include an element for the statutory tariff, because otherwise the rider is superfluous. So it's not talking about the combined effect of the non-whiplash injuries, it's talking about the combined effect of the whiplash and the non-whiplash. So that's the first point, it's an inclusive combined effect. But the second point is, and it's consistent with the submission that I've just been making, is that the only limitation which the statute is here putting upon the global assessment of damages is that it has to be subject to the limits imposed by regulations under this section. What section does what regulations does the section enable the Lord Chancellor to make? It enables him or her to make regulations about whiplash injuries and their minor psychological travelling companions. So that, again, in our submission, is making clear that the ambit of the statute is, as I've already suggested, intensely focused on whiplash claims.
So it tells you nothing about the $64,000.
It doesn't help you in any way with the $64,000 question, and though one might not be able to refer to it, and it doesn't help you even if you could for interpretive purposes, it might be thought quite amusing that my learned friend, Mr. Allen, quotes Lord Wolfson in Parliament in his skeleton to say, oh, well, we don't need to worry about that question because the courts will be able to sort it out. So here we are. My Lord, just before we leave, I'm not suggesting it adds much, but we get an echo of section 3.8 just for completeness in section 5.1, which you've got traversing pages 9 and 10. So this is the section that legislates for the exceptional circumstances uplift. At C, regulations can be may provide for the court in a case where the court considers the combined effect of one, I will translate, a scheme injury, and two, a non-scheme injury, to determine that an amount greater than the tariff amount is to be taken into account when deciding the amount of damages payable for pain, suffering and loss of immunity in respect of both types of injury, both the scheme and the non-scheme. So what we have there again is a recognition that the court will be awarding damages in certain circumstances for a mixture of tariff and non-tariff injury, and it provides that in making that award, the court can take into account an uplift on the whiplash aspect. But again, there's nothing in this section either to suggest that the Act is in any way seeking to tamper with the measure of damages payable at common law for injuries other than whiplash injuries and their minor psychological associates. So it's against the background that we say that the Act does not impact upon the assessments of damages to anything other than whiplash type injuries, that we say that therefore the Act must leave unaltered the traditional common law approach to all non-scheme injuries, which would include the principle that all damage attributable to those injuries will be compensated, notwithstanding that it may also be concurrent with damage which is caused by a different injury. There is nothing in the Act which rips out of the common law the compensation of all the symptoms which are attributable to the non-scheme injury. And it's for that reason that we say the real contest is the contest between the approach of the district judge, which is my secondary case. My learned friend Mr. Weir, who is more theological in his approach than me, eschews that and just supports my primary case, as I understand it. The primary case is that you just add them together. And obviously it's clear from the interventions of at least my Lord Justice Stuart-Smith that that's not necessarily a submission which encounters plain sailing. Let me just try to encapsulate why it is that the claimant does support that as the primary case. We take as a starting point that a simple aggregation is not inimical to the policy of the Act, because the whiplash element within the aggregated award will still be far lower than the whiplash element of the damages would have been prior to the Act's enactment. And it's also, of course, that's not the only policy of this Act. As my Lord the Master of the Rolls has observed, the policy 1 is to suppress damages for whiplash injury, but policy 2, or it might be said policy 2A and 2B, in fact, policy 2, common to policy 2 is you also streamline the procedure by getting them into a portal. And there are two sub-elements of that. One element is it just makes it quicker and faster and takes up far less in the way of public resources. But the other point, of course, is the portal in question is not like the pre-existing portals for whiplash, I'm so sorry, for personal injury cases. It's a small claims track portal, so it takes them out of legal costs as well. Defendants no longer have to pay solicitors' charges. They do have to pay, of course, the medical reports and court fees and such like. And that policy also inures, because one...
When do they pay the court fee?
I couldn't give you a quick answer.
They don't pay the court fee when they enter the portal, do they?
No, I assume not.
There's no fee until they enter the court system.
That must be right.
So until the stage 3 case,
It's not called stage 3.
No, it's not called stage 3. But in the old language, stage 3, until they actually go from the portal into the court, proceedings then have to be issued and a fee paid.
I assume that's right. I assume yes.
So in other words, the idea of the portal is that the case is settled after the medical report, and if it's not, and the damages can't be agreed, it then gets sent to the court. It should be by an API, but it's not at the moment, for determination within the whether it's small claims or fast track.
Yes.
Well, small claims.
Quite. Presumably that is determined by how much you say that you're seeking, because it's a simple. If it's above £5,000 in a road traffic case, then you're not in this process.
How are these claims funded for claimants to be represented?
As I understand it, because costs aren't recoverable, they are done on what would once have been called a contingency fee basis. So they sacrifice a percentage of their damages, which of course has been lawful since the Jackson reforms under a damages-based agreement.
So they're actually funded on DBAs.
There's no evidence about it, and I have to say I don't actually know how these two specific cases are funded. But I think in the market, where solicitors, not just in personal injury cases, but in small claims generally, if you instruct a solicitor for a small claim, it might be different if there's an insurance company or something involved, but if you as a private person instruct a solicitor on a small claim, then if it's a money claim, then usually the solicitor will be taking a percentage of the damages, which is as I've said, has been lawful now for 9 years.
So it could be a benefit of, I suppose it could be a benefit of household or other insurance.
Well, there certainly are legal expenses insurance active in this market, as if your lordship throws all your mind all the way back to Sarwar and Adam, for example, a case I think your lordship did many years ago, and probably hasn't stopped thinking about since.
I try not to. The interesting thing about that, most interesting thing about Sarwar and Adam is that it was being argued on 9/11.
Yes, that's absolutely right. Yes, I remember that very
before the then Master of the Rolls.
I remember that very vividly. Yes. Anyway, that I think is the answer. That I think is the answer to your lordship's question about funding. So it's not inimical to the policy of the Act, because the whiplash element is still suppressed. Therefore, the overall level of damages is still suppressed. And therefore, the case would, in all probability, still be within the portal and the streamlined process. And therefore, also, it's on the small claims track, which has been expanded to £5,000 for this sort of case. And so the defendant still gets the benefit of the cost saving. And we also say, in terms of aggregation, it's consistent also with that it's the simplest exercise. The whiplash element is just taken from the tariff, and the non-whiplash element is taken from the Judicial College guidelines, to which lay people are referred by the claims guide, as well as Mr. Weir points out. And I appreciate that might still give rise to some subtlety in a case, for example, like Briggs, where there are multiple non-scheme injuries. But in an awful lot of these cases, it won't give rise to any difficulty because there's only one non-scheme injury, and Rabot is an example of that. So you just look at the JSBs for knee injuries or minor injuries, and you can see it very easily. And it also, the other advantage of aggregation means it does eschew the need to have a forensic attribution of particular losses of amenity to one limb of the injury rather than another limb of the injury. And although my learned friend Mr. Allen, he showed you the medical reports and said there will just be an extra sentence or two. But in my respectful submission, that doesn't necessarily follow. I mean, that's a medical report that has been created in the context of an area of law where the rules aren't clear. But if the rules become clear that you don't just aggregate and you have to have some forensic attribution of one aspect of the symptomatology to one injury and another aspect to another, then you are quickly going to see much more complicated medical reports where claimants are going to be advised by their solicitor to give very clear evidence if they say that a loss of amenity is attributable to something other than their neck and back injury.
But that's not specific to your preferred approach, because even on your preferred approach, there's scope for the medical report to be much more or reasonably precise in allocating consequences to each injury.
It certainly is the case that if any claimant that wants to maximise their injury where the damages are at large, obviously has is well advised to give a vivid history in respect of that aspect of the history to the clinician. I do accept that you get that come what may. But what you don't get is the potential, or in the same way, you don't get the potential for going to a hearing and having an argument about what label do you attribute to what precise loss of amenity. All in circumstances where these cases are very streamlined. And on that, and also on that basis, I would add that we, for understandable reasons, and have been looking at the learned district judge's judgment. It's important also to remember in mind that is a highly atypical judgment. I mean, that is a judgment that exists precisely because the law is uncertain, and the judge has gone off and reserved judgment and gone into matters in detail. I think she actually says after discussing the situation with her designated civil judge. And obviously, what it is she, I think.
It is.
It is. Yes. Did I not say that? Forgive me. I meant to say she because anyway, it's not a typical judgment. What is, obviously one doesn't expect to get any sort of reasoned judgment in these cases. One expects to have a few sentences from a judge. It's a 10-minute hearing if there's a hearing at all. So again, if it's consistent with our approach, we say simply to add the two elements together. Certainly what we commend is not inconsistent, we say, with the Act. In fact, we say it's consistent with the Act for another reason.
Mr. Williams, forgive me. You've just moved on very quickly.
Yes.
This is normally a 10-minute hearing. Is that usual?
Well, that's my understanding, but I might see my learned friend scowling. So, that's what I've been told on my side. The Master of the Rolls, of course.
I don't think they're 10 minutes, but they're 3/4 of an hour.
Yes, but I think your lordship described attending a stage 3 hearing.
No, I know the difference.
Yes.
I think these would not be 10 minutes, but very little is 10 minutes. But they're bulk listed often.
We did push to get through 10 minutes with counsel on both sides.
I think our understanding is these are usually listed for 30 minutes.
30, is it?
45.
Okay. Well, what I'm getting slightly. I mean, what I'm being told is there's not a uniform approach, and certainly in Birkenhead, they're bulk listed. But it does. Obviously, different courts may have different practices. But,
yes. Well, maybe uniformity would be a good idea, but that's something we can look at outside this case.
But also, of course, when my learned friend, for example, says this is what they're listed for. They're partly listed for that in the same way that the judgment is atypical, precisely because the law is unclear, so there's a scope for argument which hopefully going forwards will be eliminated, for good or for ill, from my client's perspective, by the judgment of this court.
Yes, but you can't really say that it would be more difficult to adopt Mr. Allen's approach, can you?
Well, I certainly would suggest that his approach would lead to considerable complications. Certainly the three-stage approach which he analyses over a couple of sides of his skeleton argument, which does involve. I mean, he criticises, notwithstanding this careful, reserved judgment, highly atypical, he criticises the learned district judge for not making sufficient factual findings and such like. So I say that his approach, where you have to sort of focus and isolate only those symptoms which are not common and are exclusively attributable to the non-scheme injury.
Well, I mean, that's not. He says that's not difficult because if it's a knee and a back, the only thing you assess is the pain in the knee. If there's a finding that the loss of amenities is the same.
Yes, well, but obviously that therefore requires a particular issue to be addressed in some detail in the evidence in a way that I've
Well, except he also says that that's the most common situation. I mean, obviously you might have the golfing situation my lord alluded to, where you've got an injury in the knee, but the injury in the shoulder affects your playing golf.
Yeah, assuming you've got a golf buggy, I suppose. Personally, I don't play golf. I would have thought that going around a golf course with a bad knee was rather awful. But there it is.
But the complications would begin, would they not? I mean, one would begin, for example, with a witness statement from a claimant who would have to deal in more detail with the separation of the sequelae of any injuries. That would then be reflected in a medical report, which you would specifically have to address and properly analyse, which these reports do not.
Indeed. And of course,
sequelae.
The court will also have noticed that there weren't witness statements in either of these cases.
No.
But there's not, and in fact, the standard court forms have a character limit. I think 500 characters, including spaces. But you are allowed to upload documents to supplement that. And of course, if one does need to have a forensic exercise of the sort my lady's just put to me, then you are likely to have exactly that. I was coming on to suggest that our case is in fact consistent with the wording of the Act and its scheme. And we've already looked at section 3.8, which simply refers to the court reflecting the combined effect. And we've said, well, if there was an anticipation that at that stage it reflected the combined effect, there would be a process of adjustment to eliminate double counting and to apply a sort of Sadler-type principle. You would expect, therefore, there to be some provision in the Act, in section 3.8 or elsewhere, for the scheme award itself to be modified as part of that process. But the only modification the Act allows to the scheme award is to uplift it in exceptional circumstances. There's no provision for it to be modified because there is there is, for example, concurrent damage with a different injury, even though the Act is contemplating.
I don't understand that submission at all. There's no reason to adjust the tariff at all. The only thing you're adjusting is the amount of damages you give for the non-scheme injury.
But then that leads to the Act nakedly, as in the very example your Lordship just put to me, making an adjustment to a common law award in circumstances where, if I'm right thus far,
yeah, because you've got double counting, because
so
it's already been compensated.
The Act isn't addressed to common law awards, doesn't change the common law in any way.
No, but it changes the amount for which you've already been compensated. It says that you're going to be compensated for the consequences of whiplash with £500.
Yes.
You just take a sum out of the air. And you can't be double compensated for those same consequences elsewhere. And that's nothing to do with amending that is an amendment to the common law, but it's the effect of the statute.
But if there is to be a totality adjustment because of an overlap between the two different injuries, then what you would expect would for there to be an adjustment to each limb of the injury. And it's actually part of my learned friend's case. He accepts there can't be an adjustment to the tariff element. So he says that to reflect the tariff, to reflect the concurrent damage, there has to be an adjustment to the common law element. In circumstances where, in fact, the Act, on my submission at least, doesn't authorise any adjustment to the common law.
But you don't need the Act to authorise it, because if you stick as closely as possible to the common law approach to multi-injury cases, whether you do it expressly or as it were, under the radar, if you've got two different injuries and you've got concurrently caused consequences, you just make your ultimate award reflects that fact. Since you can't adjust the tariff award, it necessarily follows that you're going to do your adjustment either to the common law assessment of damages for the non-tariff injury, or to the aggregated sum when you get that one. That's not interfering with common law at all.
Well, but
except for the fact you don't know how much is in the tariff for the jointly caused pain.
right. Well, and that's a
but it's not much.
It's not much. I think there's not a, obviously it's a completely standardised award that doesn't take into account loss of immunity in any
It does. It compensates
yes.
you for all the
Indeed.
loss,
Yeah.
which is either solely caused or concurrently caused by the whiplash.
By
injury.
the whiplash injury. It
Exactly.
compensates for the whiplash.
We just don't know how much it is.
But on your lordship, on the very point your lordship has just put to me, which I, with respect, I agree with a great deal of it. Your lordship says, well, you can get to the outcome that prevents double counting by adjusting the non-whiplash element because you can't adjust the whiplash element. But my point antecedent to that is, well, if the court anticipated, if the Parliament had anticipated a sort of process of corrective adjustment to make sure that there wasn't the overcompensation resulting from mere aggregation, then you might have expected a statutory facility to adjust the tariff award, rather than artificially lumping all of it onto the whiplash element.
You don't need it.
The non-whiplash element.
You don't need it. It's going to be the same adjustment whether you were to make it to the whiplash award. It's entirely hypothetical. Say there is within the whiplash award 50 quid for pain, suffering, loss of immunity, which is concurrently caused. That's not true, but notionally it's there.
Yeah.
It's there. If you could identify it, it wouldn't matter whether you reduced the whiplash award by 50 quid or some other figure to reflect the joint causation, or whether you did it to the common law assessment of the non, or you did it to the whole thing. You just make an adjustment. Broad brush, normal common law principles, you take into account the whole thing. The problem is we don't know what the 50 quid is.
Yes. And of course, if I'm right on my first point, that doesn't matter. But,
in your primary case?
Yes.
Yes.
So far as the point, obviously I take your lordship's point, but if one posits a situation where, let's imagine the whiplash is very much the subsidiary award, somebody's broken both their legs, I suppose then you'd be out of the portal, so that's a bit too extreme. But someone has got, really quite a bad leg injury and they suffer a really quite transient whiplash injury, but it still stops them playing tennis for a couple of weeks or something like that. In my respectful submission, in those circumstances, if you're aggregating, if your aggregating wasn't adjusting, it's curious that you have to adjust the main injury to
reflect. Doesn't matter what you adjust. You've still got a notional 50 quid.
Yes, well, I obviously understand that point, but and I hope your lordship says the countervailing point I'm trying to make. So I accept you can make it work that way, but that's a different question from saying if it was intended to work that way, why wouldn't Parliament have introduced the flexibility to adjust the tariff award in a mixed case? And your lordship's answer is, well, they don't need to because of the flexibility of the common law, and that might be as far as I can take it. So I think really most of the, because on our approach this really does reduce to a fairly tight point of statutory construction. There's not actually a great deal more to say than that.
It doesn't really, does it? You've just said that 3.8 says nothing about the what I call the $64,000 question. So it doesn't reduce to a tight question of statutory construction.
Well, maybe
it may reduce to a purposive construction.
Well, yes, I wasn't by tight. I suppose by tight I meant short. I'm not suggesting. No,
Well,
the answer.
I agree the point's short.
The answer. The answer is not. The answer is there is not a clear answer waiting to be excavated from the wording of the statute in isolation. I think probably we can all agree with that. But where at least I think Mr. Weir and I invite you to excavate is looking at the way in which the statute is so narrowly addressed to the whiplash claim, with the proposition that therefore it simply cannot be having the effect for which my learned friend Mr. Allen contends, of making radical impacts on the assessment of the non-whiplash injury in the way that he argues. And as I've said, in the Rabot case, if we use it as an example, in Rabot, firstly, from the point of view of my Lord Justice Stuart-Smith's inquiry, the view we take is that if Rabot was assessed on a traditional basis, the personal injury element, the whiplash element of the damages would probably have been worth about £4,000. It's just under a year. As we've seen at the medical examination, the symptoms are still fairly severe. And if you add in the symptoms to both knees as well, a judge would probably have allowed something in the order of about £5,500. So on our primary case, firstly you see that defendants can still be very satisfied with the effect of this legislation, because on our case at its highest, it's suppressing the overall all award. It's suppressing the award overall to under £4,000, less than under the old scheme the claimant would have got for the whiplash alone. And of course on the small claims track.
But why should he? I mean, if the uplift at common law would have been only of £1,000, why should the uplift here be much more than that?
Well, precisely because it's wrong to view it as an uplift. It's a common law. In that award of £5,500, the knee injury and the whiplash injury are there side by side. And so I'm not suggesting.
It's not really wrong to look at it as an uplift, because if you look at that case we were showing, I'm sorry,
Connolly.
Connolly, it's got so many names. If you look at Connolly, you took the sort of main thing, which is in this kind of case normally the whiplash, and you said that caused quite a lot of bad stuff, but he also had a bad knee and a bad rib, or whatever it was, which was a bit more painful, but it actually couldn't have done all the things he wanted to do with the whiplash. So we had £1,000 or whatever it was in those days. And what you're saying is that we bank the £500 or £1,000 for the whiplash, and then we start an entirely new exercise on the false premise that the only injury is the knee.
But that outcome is an artefact of Parliament having only interfered in this extremely limited way, so it has suppressed the whiplash.
It hasn't. I mean, I suppose this is the question, but the question is whether it has only interfered in a limited way. It might be said, and Mr. Allen does say, that it's interfered in quite a major way, because every element of pain, suffering, loss and damage that is attributable to the whiplash is only compensated by the whiplash payment. And you can't have a penny more just because it would also have been caused by the knee.
I mean, that's the whole point. It is also caused by the knee, so you're not compensating something which is caused by the whiplash. You're compensating something that was caused by the knee. I'm sorry, I don't understand that. I mean, if you can't play badminton, you can't play badminton. Yeah, but the reason you can't play badminton is because of your knee as well as because of your neck.
Yes, I know, but you're being compensated for not playing badminton.
It's still an effective cause.
And I understand it's an effective cause, and you could sue the person who, if they were different people, you could sue them both, but you wouldn't get double damages.
No, quite. But that takes us back to the point that I made at the beginning. That's quite an instructive example, because if it's different people, you get the common law knee injury from one and you get the whiplash from the other. On the happenstance, it's the same person. According to Mr. Allen, you get less for everything than you get for the knee injury alone if the tortfeasor is different.
Well, that's the point.
Our rhetorical question is, how does the statute lead to that conclusion?
I mean, I agree that the analysis is interesting, because if it's different people, if A causes the whiplash at the same time as B causing the knee, it may be unlikely, the statute says that you get, always say 500, I don't know why, but I think that's the lowest figure. You get 500 for the whiplash, which includes not being able to play badminton, because you couldn't play badminton as a result of the whiplash. And when you come to sue B for the knee, the defendant says, well, I'm not paying for the, I may respond to a contribution notice from A, but I'm not paying you again for not playing badminton. And that analysis seems to me anyway to have some possible merit. I mean, I want to know why it's wrong.
Yes.
Can I make a suggestion? The reason why it might be wrong is because in a contribution claim, all that you would be, the person claiming the contribution would be able to show that they had paid was the small amount within this tariff, and therefore that is the only, all that, for example, the other tortfeasor could say when he says you've already been compensated, you would say, well, my common law damages are £5,000. What do you say my compensation I've already received is? To which the answer
Well,
is
the compensation you've already received. I mean, this is the, you know, this to me is the central nub of the case, and it's the question is whether the statute has said that if you're compensated for whiplash properly, you are compensated for good and all consequences of that whiplash, even if they are the consequences of something else, or not.
Yes.
And my Lord's analysis is, well, when you come to sue B, and it does highlight the point, when you come to sue B, B can say, you've already been compensated according to statute for not playing badminton. It may be a very small sum, but that's all you were entitled to. You can't claim a bigger sum, which if you'd sued me first, you would have got. Now, my question is that right? Because is there anything inherently wrong with the situation where if you're injured with whiplash by A and knees by B, you're advised by your lawyer, if you have one, to sue B first?
If you sue B, if the claimant simply sues B, which they would be entitled to do, they get their common law damages.
Yes.
B would then be entitled to make a contribution claim against A.
Yes.
Which would be, but A would say, well, if sued, because the critical wording in the statute was would if sued have been liable.
Yeah,
I would if sued have been liable for 50 quid, in
Yes.
taking my example.
And that would
I'll
depend
give you 50
on
quid.
the wording of the Contribution Act.
Yeah.
And that would depend, and we have those in much more complex building claims. We often see that argument
Yes.
taking place. It's not unknown to the common law, and with the benefit of the Contribution Act.
Yeah.
Anyway, look, it's 1 o'clock,
Yes.
Mr. Williams. Fascinating argument. I suspect we will go over a little this afternoon, but I suspect we will
Not
finish.
too long. No, I would hope to finish quite shortly after 2, but I would see if I can collect my thoughts and answer some of those questions at 2.
We've certainly got to the nub of the case, I think. So
Yes.
see you all at 2 o'clock.
All right.